The January 6th Select Committee members are immune from prosecution. Welcome to Law and Society. Please subscribe and let's talk about this briefly. I haven't heard anybody really talk about this, but what the January Select Committee did was a legislative act. And unlike with presidential immunity, which the Supreme Court picked out of thin air, the speech or debate clause actually is enunciated in Article 1 of the Constitution, and it immunizes January 6th committee members from vindictive prosecution by Donald Trump's DOJ. So before I talk a little bit more about it, I'm going to give you I'm going to read you what it says. In Article 1, Section 6, Clause 1. The senators and representatives shall receive compensation for their services to be ascertained by law and pay out of the Treasury of the United States. They shall, in all cases except treason, felony, and breach of peace, be privileged from arrest during their attendance at session of their respective houses and in going to and returning from the same. Now, the critical pertinent part. And for any speech or debate in either house, they shall not be questioned in any other place. So that is a blanket immunity. I'm reading this from constitution.congress.gov. I provided the link to it below in the description box, so you can read it yourself and also read the historical background of the speech or debate clause. What I want to do is briefly read to you what the overview is. The Supreme Court has described the speech or debate clause as a provision that cannot be interpreted literally, but instead must be construed broadly in order to effectuate the clause's vital role in constitutional separation of powers. Deceptively simple phrases such as shall not be questioned, speech or debate, and even senators and representatives have therefore been accorded meanings that extend well beyond their literal constructions. Arguably, this purpose driven interpretive approach has given rise to some ambiguity in the precise scope of the protections afforded by the clause. Despite uncertainty at the margins, it is well established that the clause serves to secure independence of the federal legislature by providing members of Congress and their aides with immunity from criminal prosecutions or civil suits that stem from acts taken within the legislative sphere. As succinctly described by the court, the clause's immunity from liability applies even though their conduct, if performed in other than legislative contexts, would in itself be unconstitutional or otherwise contrary to criminal or civil statutes. This general immunity principle forms the core protections afforded by the clause. Once it's determined that the clause applies to a given action, the resulting protections from the liability are absolute, and action may not be made the basis for a civil or criminal judgment against a member. So you can read more about that in the link that I provided in the description box. And we have seen the speech or debate clause being played out where Mike Pence used that to try and not testify, saying that his scope, he was covered by the speech or debate clause because he was acting as president of the Senate. We didn't really get to see all of that adjudicated, but what we really got to see was the weight of the speech or debate clause and the absolute immunity it vests on members of Congress when they are partaking in legislative acts. Now, January 6th Select Committee was conducting an investigation of a major crime that had occurred in Congress and had to be investigated in order to provide the legislative branches with suggestions and recommendations that the legislature would then adopt. Therefore, everything that was happening with the legislative function in the January 6th committee, their investigative roles, everybody who investigated on their behalfs, their aides who worked on the January 6th investigations, all of that is part of the legislative act that we see in the recommended section of the January 6th committee report. So if you don't have a copy of the January 6th committee report, I have provided a link for it that directly will take you to the website for the January 6th committee, and you can download the report yourself. I have mine downloaded and highlighted. And so I'm going to go to the recommendations. After drafting their full report and giving the public and the legislature an account, and the DOJ an account of what the investigative community found, they recommended that there be reforms made to the Electoral Count Act. To deter from future attempts to overturn presidential elections, the House of Representatives has passed H.R. 8873, the Presidential Election Reform Act, and the Senate should act promptly to send a bill with these principles to the president. H.R. 8873 reaffirms that a vice president has no authority or discretion to reject an official electoral slate submitted by the governor of a state. It also reforms Congress's counting rules to ensure that objections in the joint session conform to Congress's narrow constitutional role under Article 2 and the 12th Amendment. Then there were criminal referrals that were made, and talked about. The second was criminal referrals as accountability. Department of Justice should also take appropriate action to prevent its attorneys from participating in campaign-related activities or activities aimed to subverting the rule of law or overturning a lawful election. Violent extremism that federal agencies need to prepare for. The disqualification clause of the 14th Amendment, Section 3. These are all recommendations from the January 6th Select Committee. Designating special national security event, declaring January 6th a special national security event. So the first, which is changed to the ECA, has happened. Then so has designation of January 6th as a special security event. And to the extent needed, consider reforming certain criminal statutes, including to add more severe penalties, talking about obstruction of justice. Then addressing the threats to election workers, that the committee should consider enhancing federal penalties for threats against persons involved in the election process. Then there is a Capitol Police oversight and the role of the media. And then the discussion of the Insurrection Act. So in all of these recommendations that are made, the committee has been troubled by evidence that Trump's possible use of the Insurrection Act, and discussed by individuals identified in this report. Congressional committees of jurisdiction should further evaluate all such evidence and consider risks posed for future elections. So by making these recommendations, and by Congress adopting the recommendations, and by the president right now designating January 6th as a special security event, those legislative recommendations were taken and they were turned into legislative acts and executive action where this report recommended that executive action be taken. So this legislative document, the January 6th Committee full report, is now in public. It is now in public view, and anybody can check it. It has been in public view for 3 years. Don't know how long it's going to stay in public view, and that's the reason why I'm asking you to go to the website and download it for yourself as a piece of history. It was, and the immunity of the speech or debate clause kicks in the moment there is a legislative act that is associated with any other legislative action. So the members of the committee, their aides, the people, the lawyers who help them in the investigation, they are all covered by the speech or debate clause because it is a legislative act. Why is it a legislative act? Because it is an investigation to further provide recommendations to Congress and to our government about what to do with the attack that happened on the Capitol on January 6, 2021. It was a legislative act, and for that, once it has been established as a legislative act, the speech or debate clause provides an absolute immunity. And there is latitude because there's always judicial review to sort of curb or expand the scope of the speech or debate clause. But as it stands now, we look at the action that was committed and not the actors and see whether that action falls into the scope of legislative act. And it does fall into the scope of the legislative act because not only was it adopted and its recommendations taken as the legislator should, the president of the United States during this investigation and the Supreme Court of the United States in Trump v. Thompson allowed this committee to conduct that information. So there's a speech or debate clause immunity, and then there is the full weight of the government by way of the president, the sitting president, and the Supreme Court that allowed and sanctioned the January 6th Special Select Committee. So the strength of the Select Committee, by way of the Supreme Court allowing the committee to move forward with its investigations, is also an acknowledgement of the fact that this is part of the legislature's oversight duty to be able to investigate a crime that happened on government property in Congress and then be able to provide recommendations. And for that, the Supreme Court gave them authority, and President Biden waived any sort of executive privilege that he may have over the documents because they are documents of the executive branch. So with that said, I wanted to really point that out because a lot of people are talking about, Donald Trump going after Liz Cheney and Adam Kinzinger and Adam Schiff and Benny Thompson and the rest of the committee members, some of whom aren't members of Congress anymore. But the speech or debate clause still protects them from the actions conducted while they were in that committee, mind you. So when the time comes that Donald tries to make these people's lives difficult, know that the Constitution is there defending these members of Congress by way of the speech or debate clause. So with that said, I will end my stream and I will talk to you soon. Please like and subscribe and take care.